and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1134 et al. District Hospital Partners LP, doing business as George Washington University Hospital, a limited partnership, and UHS of DC Inc., general partner, petitioners, versus National Labor Relations Board. Mr. Lominac for the petitioners, Ms. Isbell for the respondent, Mr. Wiesinger for the intervener.
Good morning, counsel. Mr. Lominac, please proceed when you're ready.
Thank you. May it please the court. The board sat in judgment on the substantive terms of the hospital's bargaining proposals, and its views on those terms clouded its judgment of the hospital's good faith. Section 8D of the NLRA is clear. Parties must bargain in good faith, but they are not compelled to reach agreement or make concessions. Thus, the Supreme Court has held that Section 8D prevents the board from controlling the settling of the terms of a CBA in order to effectuate Congress's intent that the parties have wide latitude in their negotiations. This court has added a warning to the board that an inference of bad faith from the substantive terms of a proposal must always be drawn with caution. In DHP 1, the board respected those boundaries and faithfully applied Supreme Court and this court's and board precedent. But in DHP 3, the case before your honors, a newly constituted board led by the dissenting member from DHP 1 threw caution to the wind. First, I want to highlight a few inexplicable factual errors committed by the board in its decision, and those errors clouded the board's judgment. First, the board expressly found that the hospital proposed to eliminate dues checkoff during bargaining. It did not. The hospital merely proposed to modify dues checkoff to eliminate automatic contributions to a PAC fund. What the hospital proposed was to eliminate union security language from the prior contract. And after finally receiving some counter response from the union on that issue, began to discuss the reasons for not wanting that language. It was never demanded as a final proposal. Regarding management rights.
Did you ever really move off of the core proposals, the 3 core proposals in this case?
With respect to no strikes, Your Honor, the hospital.
Extended management rights or the discretionary wages?
Yes, Your Honor. The hospital did move in many respects in each of those proposals. The no strikes.
It seemed like that went on for a period of close to 18 months.
14 months was the period during which a no strike clause was proposed, along with grievance and mediation, and as well as the management rights proposal. As the record reflects, the parties made considerable progress with respect to management rights, including George Washington University Hospital withdrawing some of the prior proposals. The no strike proposal itself was withdrawn, and the board wants to make a lot of the fact that a ULP charge had been filed prior to that. The difference, however, is that that was not the end-all be-all when that no strikes clause was withdrawn. Bargaining continued for several more months. The purpose of finding no strike clause insistence, along with no arbitration, along with broad management as a bad faith bargaining tactic, is that it stalls negotiations. So the fact that the hospital withdrew that proposal goes directly towards that issue of good faith bargaining. We are trying to get to an agreement here. Regarding management rights, the board, in another glaring error, chastised the hospital for specifically proposing language stating that the hospital would receive constructive criticism from the union at its sole discretion. And the board said, well, that's hardly a bargaining proposal at all. The board overlooked the fact that it was the union that actually proposed that language. The union proposed that language, and it was in the prior CBA.
Was the sequence that when the union responded on management rights, then the next day was when the hospital put into the proposal, the grievance and mediation and the no strike provision.
The grievance and mediation and no strike provisions came in March. The management rights provision was initially proposed in December of the prior year, so December of 2016. And then the management rights proposal, and then the grievance and mediation proposal and no strike proposals were offered and discussed.
Right, but were they offered and discussed? I thought the record says that it was the day after the union counter proposed on management rights, but am I missing the?
It was around the same time. The parties were making progress on management rights. Yes, you're right. It was right around that time if it was not the next day.
It was not the next day?
If it was not, I don't recall specifically whether it was the next day, but it was around that same time period.
Okay, so, but is it, I thought what happened was there's a management rights proposal on the table. The union responds, joins issue on management rights and gives a response. And then the next day, the employer comes back with mediation and no strike.
That was not a specific response to management rights. The parties were moving along with management rights. And the hospital was making concessions with respect to management rights. And then the no strikes clause and the grievance and mediation proposal were made.
The next day?
Yes, or I believe it was the next day. It was right around there, but they were not, it was not specifically linked to those. One of the inconvenient facts that the board overlooked with respect to the management rights clause is that, again, the union accepted most of the provisions of that clause. And while the board does take issue with the expansiveness of the management rights clause, that's exactly what a management rights clause does. It gives the hospital broad discretion to act. It waives the union's right. It waives employees' rights in certain respects. Now, the board can't seriously attack the no strikes and no lockouts clause. That is a standard contract provision. The board's major issue with that clause is that it accompanied a provision that removed arbitration. The board was wrong to conclude that the lack of arbitration rendered the hospital's proposals unlawful. Arbitration is not always the quid pro quo for no strikes, and the Supreme Court has held as much. Think about this. Without arbitration, and assuming that mediation is unsuccessful, employees or the union could file unfair labor practice charges with the National Labor Relations Board claiming violations or breach of the contract. When arbitration is part of a collective bargaining agreement, the board typically defers its decision on that issue to arbitration. But when there's no arbitration, the board will rule on it. Section 301 permits parties to file breach of contract claims in court. Complaints with administrative agencies, the EEOC, the DOL, all of those could be filed. The board ignored that. The board also ignored the fact that the parties throughout their period had had one arbitration. The hospital lost that arbitration and was not happy with that result. Arbitrators are unpredictable. Mediation is a well-proven method of dispute resolution. The hospital was willing to accept the risks of court and administrative agency litigation at the expense of arbitration. This case is nothing like the cases that the board cites and relies on.
Now, let's move on to your withdrawal recognition. Did there seem to be any dissatisfaction before that time?
There is record evidence of apparent dissatisfaction, which the union has tied and the board is tied to it not reaching a point of majority status, majority wanting to withdraw until the wage issue.
In this case would be that temporal proximity with respect to when you actually withdrew, and then with respect to that October 12 bargaining brief.
The bargaining brief?
Yes.
Well, and your question is whether or not there's...
Yeah, in other words, you have the bargaining brief and then you've got the petition and then the withdrawal shortly thereafter. So I'm trying to get a sense of, was there dissatisfaction by the employees well before that, such that there couldn't be that temporal proximity? There
was dissatisfaction leading up to it because the petition was signed by employees leading up to it. However, of course, after period, the October time period when the bargaining was taking place, and then that brief was issued, the ultimate numbers on that petition for
But 50 or so members signed the petition in that 2-week period. So I'm trying to get a sense of why just during that time period as opposed to well before.
well, I think, Your Honor, we can only speculate about that. There's no allegation and there's no finding of any unlawful conduct with respect to the petition, other than the pure, lack of a bargaining relationship from the employer's perspective. In other words, it wasn't challenged that the hospital solicited the decertification or had any, fingerprints on that, if you will. And in fact, that distinguishes this case from some of the other cases in which that was part of the challenge. But here, there's no issue with respect to the legitimacy of the withdrawal of recognition, provided, of course, that the hospital prevails in its position that it had no bargaining
But you are
obligation.
tied to a misrepresentation in that essentially challenging the employees that they wouldn't get raises or that the union was not effectively bargaining on their behalf, and that was attached to the withdrawal.
No, Your Honor, the DHP board, the third iteration of this case that's before you, the majority did not consider those bargaining briefs. It was never alleged or found to be rather unlawful to provide those briefs. And if you refer back to DHP 1, the majority's decision in a footnote explains why that can't be considered or found to be evidence of unlawful intent or unlawful action.
But did you do any attempt to clarify that messaging, I guess, then?
Clarify the messaging
That you're attached to essentially that alleged unlawful comment, that whole taint with respect to that's the reason for the withdrawal, that you all are part of why these employees were signing the petition in belief that the union was responsible for them not being able to get raises.
Well, again, that was not found to be unlawful. But as far as the statements themselves, that's certainly protected by the First Amendment, Section 8C of the Act, which codifies the First Amendment protections to explain that. And that's part of the give and take of bargaining, right? And how that process works itself out. The union at any point could have called a strike. And I think that's what the board really misses here. Those economic forces could have been at play by the union. Instead, they decided to go to the board and gamble with board litigation to challenge the employer's conduct rather than substantively engage. And once meeting a point where they no longer wanted to do that from the union's perspective, call a strike. They never did that.
Can I ask you that there's two legal propositions that kind of frame the board's analysis, and I just want to make sure.
Yes.
I don't think you disagree with either of the legal propositions. I think what you may disagree with is whether the standards are met here. But I just want to make sure you don't disagree with either of them.
Yes.
The first one is, it must be decided whether the employer is engaged in hard but lawful bargaining to achieve a contract that it considers desirable, or is unlawfully endeavoring to frustrate the possibility of arriving at any agreement. That's one. And the second one is, an inference of bad faith bargaining is appropriate when the employer's proposal, taken as a whole, would leave the union and the employees it represents with substantially fewer rights and less protection than provided by law without a contract. Those are the two sort of propositions that frame what the board did. You don't disagree with either of those as stated.
I do not agree with those. I disagree.
You don't disagree with.
Correct.
Yeah.
I'm sorry. I do not disagree with those. I do disagree with the board's recitation of that. After citing that case law, the board then conveniently leaves out in its decision substantially fewer rights. And it goes to say if it would leave the board, if it would leave the employees with fewer rights. This is not one of those cases, as we've talked about, as I've talked about through the briefs and here today. This is not one of those cases where employees were deprived of anything other than what the hospital was proposing. This was not a last best and final offer. This was not a take it or leave it approach. Even without the union or without a contract, employees would not have had progressive discipline. They wouldn't have had seniority, layoff. They wouldn't have had time off for a union business. They wouldn't have had attendance guidelines. They wouldn't have had contractual wages and benefits. All of those things exist. The board engages in hyperbole. They overstate the issues. They overstate and dramatize the impact of all of this. At the end of the day, Your Honors, the law does not provide for a deal by a union. The law does not guarantee better rights, better benefits, better wages with unionization. The law requires good faith bargaining, and that is what the hospital did here. We would respectfully, therefore, ask the court to grant the petition for review and deny the board's cross application for enforcement. Thank you.
Thank you, counsel. From the board now, Ms. Isbell.
May it please the court, 5 minutes of my time has been reserved for Intervenor Union Counsel. Good faith bargaining doesn't require that the parties reach an agreement. It just requires that they come to the table with an open mind and an intent to reach an agreement. And what the board found here was that the hospital's proposals, taken as a whole, would have given the union and the employees substantially fewer rights than they would have had without a contract. The broad management rights clause, the no strike clause, and the grievance non-binding mediation clause, taken together as a whole and insisted upon for 14 months, show that the hospital did not truly intend to reach an agreement. The board does look at proposals, not to decide whether those proposals are good or bad in and of themselves, but to decide whether or not they show an intent to reach or an intent to frustrate agreement. What's in the individual proposals is less important than their combination and how they work as a whole to minimize the union and the employees' rights. So is it true that some of the same management rights were included in the expired contract and the new management rights contract or management rights proposal? Yes, of course. But this management rights proposal went further. It allowed the hospital to subcontract all bargaining unit work. It allowed them to have supervisors do all bargaining unit work. It allowed them to change any rule, policy, or procedure without consulting the union. That's the kind of thing a union would have the right to be consulted about without a contract. You couldn't change a work rule without going to the union and discussing it with them first, or at least giving them the opportunity, notice and opportunity to bargain. The no strike clause.
Can I just ask you, so on that one alone, on the management rights alone, so if an employer, if that was their be all end all, and they really cared about management rights, and then just take out of the field division, no strikes, or a mediation is arbitration, and suppose the employer doesn't care about those, but they really just want broad management rights that are, as you might say, they don't get you any better off than if you didn't have a contract. If that alone was just insisted upon and to the ends of the earth in the course of a negotiation, would that alone indicate bad faith bargaining?
I don't think so. Let me talk this out with you. If the union has the right to strike, then they have the right to enforce the parts of the agreement that are contained in the agreement, whether that's wages or progressive discipline. They have the right to go to an arbitrator to enforce or to find out whether or not a discharge is for cause. For cause discharge was taken out of these proposals. So that was one of the things the union insisted on. So with just a broad management rights, everything else the union wanted, I don't think we would be here. One of the issues in deciding whether or not these are bad faith proposals is what was the union getting out of it? You can ask for the moon, but in the end, to get to an agreement, the union there needs to be a sweetener in there for the union. And sometimes that's not a no strike clause. Sometimes it's arbitration. Sometimes it's higher wages, but there has to be a back and forth. And here there is not that back and forth. Did they negotiate? They did on things like job postings, vacancies, the union bulletin boards. They discussed that stuff for months. But the big issues, they held strong. The union really wanted for cause discharge. It had been in the old contract. The hospital refused to do it. And you'll notice in their reply brief, they talk about the fact that it was okay because an arbitrator would have read it into the contract anyway. Except that under their proposals, there would be no arbitration. It would never go to an arbitrator. And the bargaining notes of this bargaining would show very clearly that they had bargained that away, very specifically. The hospital was not going to agree to it. And if just cause discipline was not important and could have just been inferred into the contract, then they could have given it to the union. The union was very clear that they wanted that one bit in the management rights clause and in the disciplinary clause, and they said no. Those things show that this was not an intent to reach agreement, it was an intent to frustrate agreement. Bargaining on the prior contract took a week. This took 30 sessions over almost 2 years. They reached a handful of tentative agreements on, let's just say, maybe not minor, but the less important issues, not wages, not discipline, not management rights. The preamble, they reached a tentative agreement on, job postings.
But didn't the union table wage demands for a significant period of time as well?
The union, if you read the bargaining notes, the union begged to discuss wages from the beginning. The company would not discuss it. The union finally put, I think in April of 2017, finally put a wage proposal on the table. It was not until May of 2018 that the hospital countered that wage proposal. When it countered that wage proposal, it came up with a two-part system. One was these wage range charts, you can see them in the record, and one was a merit-based, not a bonus, but merit-based raises. Neither one would they negotiate. They were very clear. They would not negotiate the wage ranges, and they would not negotiate the merit proposals. Performance evaluations, which would be the basis of your merit raise, were taken out of the grievance non-binding mediation clause. You couldn't grieve it, and you couldn't take it to even non-binding mediation. So they wanted no union role in wages whatsoever. But on the issue of timing, it was the union begging to discuss economic issues and wages from the beginning. One last thing I would just like to say, there does not have to be a last best and final offer. When we're talking about surface bargaining, what we're talking about, as the Fifth Circuit memorably called it, shadow boxing to a draw. Nobody has to say the words last best and final. It doesn't have to be take it or leave it. It just has to be where the record as a whole shows an intent to frustrate rather than reach agreement. If there are no further questions.
Thank you, counsel.
Thank you.
Hear from the intervener now, Mr. Wissinger.
Good morning. May it please the court. Michael Wissinger on behalf of the intervener, 1199 SCIU. I would like to go straight to the question Your Honor was asking of my colleague of the combined effect of these proposals, which taken as a whole would leave the union and the workers with substantially fewer rights than if they didn't have a contract. Really two parts to this equation from our perspective. First, as counsel for the board briefly explained, as long as there was no contract in place, the parties were bargaining, the existing conditions held. Those existing conditions, apart from the wage increase, were substantially better than what the employer was proposing. Second, if the union had agreed to what the employer was proposing, it would have shackled its members with a contract that was meaningless for them as individuals. Proposals such as these strip the union of a way to represent their members on the decisions that are important to them. Workers want a few things in a contract. They want to see written down, what are their wages going to be? What are their benefits going to be? They want some job security. They want a voice in the workplace, and they want a way to redress, most often, an unjust discipline, a way to enforce the contract. As counsel for the board and the record reflects, the proposals here provided none of that to these workers. The management rights clause, the employer retained all the control, right? All control over wages, benefits, the work itself, and the elimination of the just cause protection. These are the things that the workers care about and what a union obtains for them in a contract. And even as to the supposed advantages that GW is touting and the items that it lists that it was willing to give, those were unenforceable, right? They admit that the only way to enforce those would be in federal court and limited to what was essentially a discharge arbitration. How hollow that sounds to a hospital cook, hospital cleaner. Everything that you might get from us, it's unenforceable. No arbitration, no right to protest. In this very measured setting, in this beautiful courtroom, I'm charged by my client with explaining to you just how troublesome these proposals were. So outside the bounds of normal behavior. The union was in disbelief. After 20 years, they sat down and the employer said, we need to rewrite this entire contract. The union knew it was in for the long haul, but it did not know just how far the employer was willing to go to break the union and break the law in the process. The union continued to hold out hope. And if you read the record, you see the union is making counters. The union is compromising. The union, if we could just tweak this, maybe we can get a contract. And you ask specifically about the management rights clause. The union agreed to most of that right away. But it was the rest of what came right after that agreement the union could never agree to. And management knew that. They say they were testing their leverage, but they never moved on the important conditions of employment that the workers were holding the union accountable for. By the last session, five agreements after 2 years of bargaining on things that were pretty unconsequential to the workers. Meanwhile, the substantial issues for 14 months go unchanged. The employer engaged in the choreography of bargaining, but they never really bargained. And they knew that if they could wait out the clock, the union, no self-respecting union could agree to what they were asking, and the workers would start to get frustrated, and they did. Your Honor asked questions about that timing, and that's absolutely correct. These workers were told, your union is preventing you from getting a wage increase. And they turned, and here we are. GW forced the union to spend 2 years bargaining nonstop over peripheral issues and held to a core of unlawful proposals for 14 months. That is unacceptable. It's unlawful. It's bad faith bargaining. We ask the court to enforce the board's order in full. Thank you.
Thank you, counsel. Mr. Womanek, we'll give you 2 minutes for rebuttal.
Briefly, Your Honors, the right to union representation does not imply a right to a better deal. The board forgets this. The board focuses so heavily on the substance of the terms, the merits of those terms, whether they were fair, whether employees would have agreed with that, whether the union would have accepted it, whether we offered a sweetener to the union. This court, the Supreme Court, and other courts have consistently held that the board cannot go that far. The board is obligated to regulate the parties' conduct at the table, not cast merit or cast judgment on the merits of the substantive proposals, the misstatements, the inaccuracies, the overgeneralizations by the board, by my friends on the other side, are alarming. Wages in particular. The company was not proposing to have all discretion over all wages. And to the extent the company did propose, the hospital did propose to retain discretion to increase wages, the board conveniently forgets that the union readily agreed to that. We have no problem with what you want to pay above the minimums. We just want the minimums established. And that was subject to bargaining, subject to negotiations, up and until the hospital received that petition. If the union believed the hospital's proposals were untenable, it could have called a strike. It did not. Instead, it went to the board, and the board misapplied precedent and found the hospital's conduct unlawful. Thank you.
Thank you, counsel. Thank you to all counsel. Take this case under submission.
Case number 24-7063. Michaela Smith, appellant versus Howard University. Ms. Dodson, appointed amicus curiae. Mr. Privis for the appellate.
Good morning. Ms. Dotson, please proceed when you're ready.
Good morning, Your Honors. Eva Schell with the Georgetown Appellate Litigation Clinic. With the court's permission, Allie Dodson will be presenting arguments on behalf of amicus.
Thank you.
Thank you.
Ms. Dotson.
Good morning, and may it please the court. Ms. Smith enrolled at Howard with the goal of practicing medicine in her underserved community of Shreveport, Louisiana. Instead, she was expelled following a one-sided disciplinary proceeding, while her male peers received leniency for similar conduct. The district court's decision should be reversed for two reasons. First, the circumstances indicate that Ms. Smith was punished more severely because of her sex. And second, Howard breached the terms and spirit of its educational contract with Ms. Smith. Turning first to Title IX, discriminatory intent is an inherently factual dispute, and a reasonable jury could find that Howard discriminated against Ms. Smith because she is a woman. Ms. Smith has provided sufficient evidence to conclude that Howard's asserted excuse for her expulsion is actually pretextual. First, she has shown that men got lighter punishment for comparable acts. Life-altering sanctions for women, but leeway for men is especially indicative of gender discrimination. At least two of the men in this case were accused of an identical offense to Ms. Smith, but received only a permanent notation in their records. And a third man engaged in even more serious conduct. He photographed an entire quiz, and these pictures were later circulated to other students. He was suspended for 30 days and had to give a presentation on professionalism. Meanwhile, Ms. Smith was expelled. And Howard claims that Ms. Smith was punished more harshly because she was unremorseful. But Ms. Smith admitted to altering her answer, and even though she explained that it wasn't her intention to cheat, she still apologized for the problem, for her mistake, and for her error. The issue isn't that the record contains no expressions of remorse. What Howard is really saying is that Ms. Smith didn't apologize in the right way. This is an inherently subjective standard, and these sorts of subjective standards are ripe for abuse by nefarious decision makers in order to conceal their discrimination.
Okay,
So
so
is-
we're,
Oh,
Go ahead.
please.
we're talking about an honor code. And so when you're looking at the comparators here with respect to the men, we're talking about cheating. And so admittedly, before she turned in her challenge, she actually changed her answer on the actual test and then turned in the challenge. So ultimately, Howard is expelling her because she actually cheated on the form. The second thing in terms of the honor code violation it appears that with respect to the other comparators, when we go back to your suggestion of the remorse, it looks like there's an opportunity for the university to rehabilitate any of the persons who are involved in honor code violations by giving them an opportunity to acknowledge their conduct, by admitting that they actually cheated, and then essentially doing something about it. And so that's why they're looking at remorse. Do you acknowledge what you've done? And are you remorseful about it so that it doesn't happen again? I.e., you could think about ramifications later. If you're a physician and then you're later sued for medical malpractice, for example, are you going to change your charting, for a patient just to get yourself out from under a particular issue? So explain that part to me about, you're saying that you don't think that she apologized in the way that they would have her, but that remorse that they're looking at seems to go to the honor in honor code violation.
Well, the facts in the record don't indicate that the men did apologize in a way that was qualitatively greater than what Ms. Smith did. For example, if you look to
But they
the,
said they cheated. They did, they admitted to cheating, and she does not. She says, I didn't intend to.
not necessarily, Your Honor, in the honor code minutes of the student who screenshotted the examination, for example, it says that he admitted to the violation. It doesn't say that he had said that he intended to violate the honor code, just that he had admitted to the violation. In fact, in his previous conversations with Dr. Ford, he had told her that even though he had screenshotted the examination, he hadn't shared it beyond personal use, even though it was later found circulating among other students. It's a jury question, really, as to whether the remorse that Ms. Smith expressed was comparable to the remorse expressed by her male peers. And this is only one of the ways in which Ms. Smith was discriminated against by Howard.
Can I just ask you on the apology question? Because the way you framed it was that she didn't apologize in the right way. Everybody apologized, but she didn't apologize in the right way. And it seems to me that what the school thought was, it's not that she didn't apologize in the right way, it's that she didn't apologize for the right thing. And those seem to me somewhat different. So if somebody says, I'm really sorry that you misunderstood, and then the other person says, I'm really sorry that I cheated. Those are both apologies. And you could say that one of them's apologizing in a different way from the other one, but then they're apologizing for different things. And if that's true, then would that undercut your submission that there was differential treatment of like situated individuals because they wouldn't be like situated individuals?
No, Your Honor, because of the subjectivity of that remorsefulness analysis, it really does go to a jury. And it's ordinarily a question for the jury to address as to whether comparators are similarly situated. To the extent that there's different inferences that could be drawn from the apologies on the record or the apologies that Howard purports happened, that would be a matter for the jury to address. As a matter of law, we cannot say that Ms. Smith was less genuinely remorseful than her male counterparts.
It can't be that every time there's a comparator that's put forward, it necessarily goes to the jury on whether the comparator is similarly situated. There have to be situations in which the court can decide that as a matter of summary judgment, the comparators are not similarly situated.
Yes, and that does happen, Your Honor. In situations, for example, where the comparators had a different supervisor or they had different jobs in the Title VII context, but those are very objective determinations. Here, what we have is a subjective dispute of material fact as to the degree of Ms. Smith's remorsefulness, and this sort of subjective inquiry is best addressed by a jury, especially when it's bolstered by evidence of the deficient process and other shortcomings Ms. Smith received, and accumulation of procedural irregularities, all disfavoring a student of one sex, begins to look like a biased proceeding. And in this case, Ms. Smith experienced several of the defects that courts have found to be indicative of bias. The Honor Council conducted no investigation prior to bringing these allegations against her. Dr. Gilland was not present at her hearing and did not submit a written complaint, even though the lab coordinators of male students did so. and her appeal was not processed in a timely manner. Based on this information, as well as the much harsher sanction she received relative to her male peers, a jury could find that this was gender discrimination. Thank you.
I have one question for you actually before you sit down, and we will give you a little time for rebuttal. So this is on the contract piece of it. There's a back and forth about whether the policy gave rise to contractual rights. And was that kind of claim, I know there was generally a contract claim discussed in the district court, but was the particular idea that the policy itself gave rise to binding contract rights something that was litigated in the district court?
Amicus believes so, Your Honor. There was discussion of the general contractual relationship between a student and their university, and that is colored by what is in the honor code in this case.
Which sounds like the implied contract claim, which that I think was before the district court, but on the idea that the policy itself gave rise to express contract rights, I didn't see where that was specifically pressed and litigated in the district court.
Well, the attorneys at the district court pointed to certain breaches of the honor code, such as not having a properly appointed student member present, that those are honor code procedures, Your Honor. And therefore, what they were alleging with the breach was a violation of the honor code, which became part of the implied contract.
And we, as a DC Circuit, have not expressly ruled on Title IX in terms of any particular burden shifting, but you relate that McDonnell Douglas is appropriate here. Apparently, both you and defense have agreed on that. Why do you believe that that's the best framework here? And then also a subpart of that question is that it seems like we don't have all of the elements presented here in terms of the burden shifting.
Amicus believes that the McDonnell-Douglas test is the most appropriate framework because of the similarity of Title IX cases in many ways to Title VII cases. Additionally, part of why McDonnell-Douglas was created was because it's very difficult to find direct evidence of discrimination in many cases. This test was created in order to give plaintiffs with circumstantial evidence a means to get these sorts of discrimination claims redressed, Your Honor. So it would be appropriate here.
Okay, and then what about you establishing essentially the prima facie case? Do we skip that, allow the employer to go to essentially the legitimate non-discriminatory reason and then allow you to go to pretext because we're here on summary judgment?
In our circumstance, I believe that the prima facie case was at issue before the district court, and Howard has proffered what it claims to be its non-discriminatory excuse for Ms. Smith. So now we are in the third step of McDonnell-Douglas, in which we're really just trying to get at the underlying question of Title IX. Could a reasonable jury find there was gender discrimination?
Thank you.
Yeah.
Mr. Primus.
May it please the court, and good morning. The evidence in this case was overwhelming that Ms. Smith tried to cheat on the exam. And the challenge sheet itself was particularly damning. And just to review it quickly, she altered letters and squeezed in letters in a surreptitious way. That's not what you do if you're just trying to seek edification. She put on the challenge sheet that her answer to question 14 was posterior semicircular canal. That was false. That was not her answer. She wrote on the challenge sheet, my answer was correct yet marked wrong. That was false. She wrote recalculation needed, obviously asking for a grade increase. So in this case, there was overwhelming evidence that she cheated. And certainly it was not irrational for the university to determine that she cheated.
But I don't think that's what's being argued. I mean, I think the other side acknowledges that there was cheating. And then the question is, was the response to the cheating on par with the response to the cheating by others?
Actually, they do not concede that she cheated. And she was Ms. Smith was very clear, and it's on the record, that she did not cheat. And that's, we quoted some of her deposition testimony on that in our brief. If you look at the minutes of the hearing counsel, it's recorded there that she did not cheat. In the lower court, she did not admit cheating. At her deposition, she did not admit cheating. In this court, in our opening brief and reply brief, she did not admit cheating.
Yeah, maybe the cheating is that's a conclusion as opposed to.
Right. Now, what she says is that she apologized for her error and not being clearer. But as was pointed out in some of the questioning, she's apologizing for the wrong thing. It's like saying, I apologize that you got upset about that. Okay, that's not an apology for your conduct. It's an apology. It's sort of an excuse for what you did. And all of her so-called apologies are actually trying to justify her cheating. She's not offering apologies for cheating. She's offering excuses for cheating. And that's what was obvious to the hearing panel. I think it's obvious to anyone who looks at the documents.
She had already passed the exam, so what does she gain from all of this?
What she gains from it is that she, and this is spelled out in our brief as well, she was on a failing trajectory for that course. She failed the second exam and the second lab exam, and she had missed the first exam. So as of this point in time, she was on a failing trajectory. She knew that if she failed the course, she'd be out because she was a repeating student. So because of that, she had an incentive to try to get a higher grade on this class. Every point counted for her. And that's what she had that was her incentive. And regardless of whether she had an incentive or not, she tried to cheat. I mean, that's the bottom line. We've heard about the comparators, and I think the dialogue so far is right on the money that the comparators all admitted cheating. There's some suggestion that one of them, I think it's AC2, been referred to that way, that AC2 admitted the violation. Well, that's what's in the minutes of the Honor Council Committee. What violation was he admitting other than an honor code violation, which is the reason why they were all there? And there was no evidence presented in the record below that AC2 was not admitting to a violation of the honor code. I mean, it seems obvious that he was. And furthermore, the testimony of the dean and the Dr. Callender, who is the HCC chair, all established that they understood him to have admitted the violation. So against all of that, the appellant has nothing in terms of evidence.
So if she had admitted to the right thing, just to use the formulation that's been bandied about, and then but was expelled, then would you acknowledge that at that point the differential treatment would go to the jury?
Well, if she had admitted to cheating, then there are these comparators. And I can't think of any reason here why that wouldn't go to the jury, but that's not, it's not the fact. It's not what was argued. It's not what the lower court found, and there's no evidence to support it. So that's my argument on that. There was a suggestion also that Dr. Gilland was not present. Well, Dr. Gilland was not the accuser as far as Howard University was concerned. He's not the one that advanced the finding to the upper levels of the medical school. And Ms. Smith was sent a letter from Dr. Wilson indicating that he was the accuser. So Dr. Wilson was present at the hearing. Now, Dr. Gilland was not present, but she had never asked him to be present. She had never asked the Honor Council to have him present. And when pressed to explain what Dr. Gilland could add, what information he could add, she came up with nothing. I mean, she said that Dr. Gilland told her that she could fill out the challenge form as she saw in the format that she saw fit. Well, it turned out she did use the standard format, and there's nothing about that verbal exchange that is exculpatory in any fashion whatsoever. She didn't present any evidence in the lower court that Dr. Gilland had something, spectacular to say, or anything exculpatory. And that way, she didn't depose Dr. Gilland. She made no record that Dr. Gilland had any evidence. And when she went to the dean, she didn't explain that Dr. Gilland had anything exculpatory to say. She complained to the provost, didn't explain that. So this whole business about Dr. Gilland is a red herring.
Just wanted to ask you about her being a repeating student. How much of an influence was that on the decision? And were any of the other comparators repeating students?
I don't believe any of the other students were repeating students. I don't believe that was the case. She was not expelled because she was a repeating student. She could have been dismissed for that reason, but that's not the way it happened. There's reference to this Promotions and Graduations Committee, which is an academic standards committee. It can dismiss a student if they are a repeating student and failed, but that was irrelevant to the decision here. As the appellant admitted at her deposition, this P&G committee had absolutely nothing to do with the decision. It has nothing to do with disciplinary decisions. The decision was made by the dean, if you look at his letter, based on the Honor Council's conclusions and findings and recommendations.
And in reference to the breach of contract, in the policies and procedure manual, I believe she kind of points out to process a lot. And your process for investigating honor code violations, there are time parameters, there's the sharing of data collected, there's notice of the charges, there's timing of the decisions and appeal options. So she's referring to a lot of the things in the process that she believes did not happen. How would you reference those things with respect to the breach of
Well,
contract?
the trial court went through all those issues and found no problem, and I see no problem. We've laid that out in our brief. On appeal, she tries to raise factual issues that were not raised in the court below. We had no opportunity to respond to them, and the judge had no opportunity to address them. So it seems inappropriate to us for those to even be considered here on appeal. But on all these procedural issues, I think the appellant can't see the forest through the trees. All of the male students were found to have violated the honor code. So there was no instance here where there was some procedural bias that favored the male comparators. All of them were found guilty. So this is not a case where there's some different outcome that results from procedural differences. And the procedural differences are very minor, and they don't really affect the ultimate decision. They weren't material. The ultimate decision was obvious that she had cheated. The only difference between her and the male students was remorse, and that's not a procedural issue. It's not a procedural issue that she was found not to have engaged in remorse. That's a substantive issue that goes to the sanction. I see I'm out of time, but if there are any further questions, I'd be happy to address them.
Thank you, counsel. Dawson will give you 2 minutes for rebuttal.
Two points on rebuttal, Your Honor. Ms. Smith did also admit to violating the honor code in the way that Howard asserts the male students did. She never denied changing her answer sheet. She always admitted to that, first to Dr. Ford and then to the Honor Council. In fact, in Provost Wuto's letter to her, he stated that her words at the Honor Council were an admitted violation of the Honor Code. But the very fact that we're up here arguing about whether her apology was sufficient or whether it was insufficient shows why this dispute is really a jury question. Reasonable minds could differ as to whether she apologized sufficiently or why she apologized the way that she did. Therefore, this is a question best addressed by a jury. Secondly, with regards to the breach of contract claim, amicus would like to clarify that we are not raising an express contract claim today, but rather looking at the duties that Howard owed to her under this general educational contract.
Right,
And
I guess I don't know that I meant to say express contract. What I'm saying is that the policy itself gave rise to contractual requirements.
Yes, Your Honor. And as far as Howard characterizes these procedural differences as minor or unimportant, that is, again, a matter for the jury to determine. The extent to which Ms. Smith was harmed by these procedural breaches is a classic question of fact. Whether Dr. Gilland would have provided exculpatory evidence, or not even necessarily that, if his presence could have helped her in some way, if a properly constituted student body could have perhaps come to a different decision. Those are all questions that are best addressed by the jury rather than as a matter of law. Thank you.
Thank you, Ms. Dawson. Thank you, Mr. Prywes. We'll take this case under submission. Ms. Dawson, you and the appellate litigation program were appointed by the court to present arguments assisting the appellant in this matter, and the court thanks you for your able assistance.
This honorable court has stands adjourned until Friday, April 11th at 9:30 a.m.